doing? What's up? Found some old school Judge Bryant from about a year and a half ago. Uh, and then I have a soft sit, disorderly conduct, going nuts from another content creator that I've been following for a while. Um, he has the whole kit and caboodle of the trial. I'm just gonna show you the highlights of it. His last day when he takes the stands, it's fantastic. So I'm gonna show that, and welcome everybody. Let's have some fun on a Saturday. How we doing, people? I have Janice Stevenson. I'm gonna play. I have two clips from this one. So we're let's go. Janice Stevenson's in this one also. She's here, and Murad's in this one too. All right, here we go.
And we're all set for January 21st at 9 o'clock. Ms. McKenzie, have a good day.
You too, Judge.
Thank you. All right, this is case number 1944593, the people of the state of Michigan versus Destiny Sierra Abate. The defendant is charged with operating while visibly impaired. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Lori Bumpus on behalf of probation.
Tommy.
Janice Stevenson appearing on behalf of Destiny Abate. Ma'am, please tell the court your name. Ms. Abate, will you please unmute and tell the court your name?
That's Janice
Destiny
Stevenson.
Abate.
There's Stevenson.
Today is the
Mark,
date set for an
my
arraignment on a
man.
bench warrant. Ms. Stevenson.
Thank you,
Thank you.
Shano.
This warrant, Ms. Abate will stand mute requested a plea of not guilty be entered on her behalf, Your Honor.
As to the arraignment on the bench warrant, the court will enter a not guilty plea on behalf of Ms. Abate. I'm assuming since Ms. Bumpus put her appearance on the record, this matter was capious at a review.
Yes, that's correct, Your Honor.
All right. Ms. Bumpus.
Yes, Your Honor, initially, Ms. Abate was placed on probation June the 4th of 2019 for a period of 12 months. She was last before this court on June the 3rd of 2020. At that time, Your Honor, her probation was extended until December the 8th of this year. Her
3
review was
months.
scheduled
Oh my
on
God.
September the 1st
We're getting old.
of this year, and that's when she came to Your Honor. At our last review hearing, the court ordered that she submit proof of having a medical marijuana card. She has provided proof of having the medical marijuana
I
card.
said, I asked somebody for proof of a medical marijuana card.
Yes, and also proof from her doctor as to why the marijuana was prescribed. However, Your Honor, since that time, I'd like to report that she has not tested positive for marijuana since her last positive was in June. However, Your Honor, I'd like to report that since our last hearing, I have received documentation from Quality Behavioral Health. It was dated August the 21st. They verified that Ms. Abate entered inpatient treatment detox on August the 8th of 2020. And then she went to residential at their facility on August the 13th. She was anticipated to be successfully discharged on September the 2nd. However, to my knowledge, she left treatment before being discharged. Since that time, I've also received a call from Ms. Abate stating that she was in Sacred Heart inpatient treatment. I did call the number back that she left. However, I was unable to verify with the counselor that she was actually there and how long she stayed. So to date, Your Honor, she has not completed treatment, to our knowledge, successfully. She still owes $1,050, and she still has not completed alcohol highway safety education. In December of 2019, she had violated her probation by not testing as ordered. At that time, Judge King did order that she perform 4 days on the work program. I checked this morning, and to date, she's performed one of those 4 days. As far as testing, Your Honor, as stated,
in
she was before the
trouble.
court in June. Since that court date, she was before the court June the 3rd. Since that court date, Your Honor, as far as testing, she did fail to report on several dates. Some of it had
My
to do
grace.
with her inpatient treatment. However, she has tested as of November 2nd, she was negative. October 18th, she was negative. On October 2nd, she failed to report. And then September 20th and September 1st, she was negative.
Okay, Ms. Stevenson.
So I am attempting to learn at this point, Your Honor, whether or not Ms. Abate is at Sacred Heart or some other facility, and there's Mr. Murad.
Christopher. Thank you, sir.
If I may, Ryan Murad, P83665, on behalf of Ms. Destiny Abate.
Yeah,
I do understand, Your Honor, that Ms. Abate was in rehab at a point in time. As of now, I do not believe she still is. Is that correct, Ms. Abate? Are you not in rehab currently as of now?
no, I'm not.
Okay. And Your Honor, I'd also like to add, after a conversation with Ms. Abate, I do think she'd be a great candidate for the mental health court, based on some of the things we've talked about. I don't know if the court would accommodate that at this time.
She doesn't have enough time.
She does not.
Oh, she's on probation since June 14th, 2019. I didn't see her until June 3rd, 2020. So she already does not have 12 months left. Anything else?
Nothing further, Your Honor.
Okay.
There's the face. Looking out her window. I would not want to be her.
I mean, I don't know. What do you want?
Judge, you're breaking up.
Bryant needs better Wi-Fi in her house.
I said, what do you want me to do with Miss Abate?
I said, what do you all want me to do with Miss Abate? I said,
Your Honor, I can't really hear you. I believe you may have asked what you want us to do with Ms. Abate.
Wait. I said, I asked you all, what do you all want me to do with Miss Abate?
Your Honor, we would leave it at the court's discretion.
Nope, I want to know, what do y'all want me to do with Miss Abate? Because
Well,
my
Your Honor,
discretion is gonna send Miss Abate to jail. She doesn't have any time with any of the specialty courts, and she just deciding to do the stuff the way she wants to do it. She just gonna do what she want to do.
Your Honor, I'm not sure how far
So
Ms.
unless
Stevenson
somebody
got before. My
go
apologies, Your
ahead,
Honor. I'm not,
go ahead. No, go ahead, counsel.
so from what I understand is that, and I did not hear Ms. Bumpus's original statement, but what I understand after my conversation with Ms. Abate is that she was on her way and she was close to finishing 60 days of inpatient treatment before she went to the hospital. I know that she has made some payments as to her probation. However, I know that she has not completed Narcotics Anonymous 2 times a week. I'd ask the court to give her an opportunity to at least get enrolled with the Narcotics Anonymous program, Your Honor. And so we can maybe adjourn this matter for a month out so we can see her progress with that specific program and with the rest of her probation. I believe she's been out of the hospital. She's not committed to any facility at this time. I do believe that there are remaining terms of her probation that if given the opportunity, she would be able to complete. I'd ask the court to give her that opportunity, Your Honor, so she could meet with Ms. Bumpus, get enrolled in these NA classes, really help her help herself, and maybe set this matter up for a month to see where she's
Hey,
doing now.
Aradine.
You know, I just decided over these past few days that it becomes so important not to waste time. And I feel like that's going to be a waste of my time. Because she has $1,000 balance. She has not completed the alcohol highway safety education. She has 3 of 4 days of workforce, which of course we're not doing workforce now. So that changes to community service, and it is going to increase. So it changes, and I would increase it. She failed to report for her drug testing October 2nd. I applaud her. I guess she checked herself into outpatient treatment or inpatient treatment, and then she left. She didn't go back. She didn't finish. She didn't get discharged, right?
Correct, but I believe that was because she was sent to the hospital, Your Honor.
Well, they wouldn't kick you out of the program. She should have went back.
And I agree. I think the court is correct.
Right.
She should have went back. Absolutely.
So she went to the hospital. Then she could have went back. When she got out of the hospital, you go back to the program. They're not gonna kick you out, and you went to the hospital from their program.
I know, Your Honor.
I just know that we just doing a lot of excuses. So she doesn't qualify for specialty courts, and therefore she has to. So she's in regular court, and regular court says if you don't do what you're supposed to do, then you just go to jail.
Absolutely. And Your Honor, I'd ask the court to empathize with Ms. Abate a bit here. This is also somebody, and I'm not making an excuse for her, but this is also somebody who was battling addiction, who is battling a bipolar disorder as well, who still managed.
Which is why she should have been referred to the specialty courts.
Digging the hole.
I do empathize with her, but I don't have the capacity, nor the patience, nor the desire to address those issues in that specific manner. So she was in treatment, she left treatment. I can't, I'm not, she was there, she left. She was doing something, she stopped. So therefore it's only one thing for me to do. I don't really understand. So she's gonna waste up my time. You want me to clog up my docket for December, then Miss Abate come back just to tell me that she didn't have a chance to do whatever I'm asking her to do.
Your Honor, the best thing I think for Miss Abate in this situation is Judge Bryant. Honestly, I think the best thing for Miss Abate.
It might have been the old Judge Bryant, but the new Judge Bryant is tired of wasting her energy on things that people are on this right here. So the new Judge Bryant is tired of wasting her energy. The new Judge Bryant,
Thanks, Devilish One.
is
Appreciate
just
it.
tired.
Would the new Judge Bryant give Miss Abate one more chance, Your Honor, to show some compliance?
The new Judge Bryant don't have patience for a lot of that either.
I completely understand.
I know y'all want that old Judge Bryant back, the one that they, the one that cared and was passionate.
I've just
the
seen
one
so
that
many
doesn't
people
care
in
and
Miss
is not.
Abate's situation that avail themselves of Judge Bryant's advice and end up being so much better. I just think that Ms.
Yeah, they do.
Abate is one step away.
Oh,
One step away, Judge. We're just asking for one chance.
Murat.
She's not. I have no confidence that she'll do it. She was placed on probation. I'll continue her to her final review of December the 8th and see where she is. And if she's not done what she's supposed to do, then it's going to be the end of the road.
Absolutely, and we completely understand. I would just instruct Ms. Abate at this time that later when she gets off today to give Ms. Bumpers a call to touch base so we can get her going in those ending classes. Thank you, Your Honor.
All right, December 8th at 9:30.
I'm looking at the calendar and the 8th is on a Tuesday.
Oh, it is December 9th.
Thank you, Your Honor.
Thank
You're
you, Your Honor.
welcome.
Thank you, Ms. Bumpers.
Okay,
Okay. All right. Oh,
so now this is the same docket, but I jumped and put clips, put markers where she's good. So this is another one, just classic Brian here. Are we digging the background? I'm not digging it. I love the new Judge Brian. And look at Janice Stevenson with her Robert Palmer video going on. Look at her. Simply irresistible. Love it. All right, let's do it. Thank you, Laura.
so we are
And
then
by
back
the
on the
way,
record in the people of
I will be posting my P.O. box. My girlfriend finally got me one because I'm just forgetful and lazy. So I'm going to have a P.O. box. And I am going to order a Lions hat. I don't know why I don't have more Michigan apparel. I should have it because Michigan is what this channel is all about. So I will be getting. Good idea, Laura. I'm going to go on Lids right now after the live and I'm going to order one. Thank you.
the state of Michigan versus Michael McCroy, case number 2045000. Okay, Mr. Perlman, you've had an opportunity to speak with the prosecutor.
I have,
How
Your
are
Honor.
How are we proceeding?
Your Honor, my client would be entering a guilty plea under a delayed.
Hold on, Mr. McCroy, you have to come into screen, sir. Mr. McCroy? Okay. All right, Mr. Perlman, you said your client will be entering a plea.
On under a delayed sentence, at which time the case would be, dismissed if he complies with the terms of probation.
Right. If I may jump in, Your Honor.
You may.
So, excuse me, Attorney Perlman is correct. So the people have offered a 12-month delayed sentence along with the anger management, again, however the court
What's
will
up,
decide,
Dave?
and then also
Thank you,
parenting
Chris.
classes. And we also made it clear that upon a good report that the people would have no objection to a 9-month review or to a dismissal at a 9-month review if the court would allow.
I love when defendants are in their work van. It's so creepy.
All right. Um,
What's up, Walter?
Mr. McCroy, I
up,
am
Courtney?
going to show my screen because you, so let me share my screen.
You tell Judge Brian.
Are
is
you
a
able
pro
to see
now.
my screen, sir? Unmute yourself, Mr. McCroy, please.
It said it's loading.
Okay. Well, while it is loading, I am going to go ahead and read them.
Is it? I can see it now, Judge. Sorry.
That's okay. And Mr. McCroy, do you understand that you have been brought to court on a misdemeanor charge and that you have the following basic rights? I'm starting at number 2 on the advice of rights form.
Yes, ma'am.
That you have a right to plead guilty or not guilty, or to stand mute. That if you stand mute, a plea of not guilty will be entered on your behalf. You may plead no contest with the permission of the court. You have a right to a jury trial and to the assistance of an attorney. You have a right to have an attorney appointed to you. However, you appear with an attorney today, so I'm going to skip number 3. You may, and number 4. Number 5, if you have a trial, you have the following basic rights: to call witnesses to speak for you at trial. You may get an order signed by the.
Sorry, Ed, just before, I did want to request the court's permission to enter a no contest plea.
Well, right now, okay, I'm just going over the rights right now.
Okay.
Thank you, darling.
All right, and Mr. McCroy, do you understand that if the court accepts a plea, that you will be giving up all of the rights that I have just read to you, that you will not have a trial of any kind. The prosecutor will not have to prove anything, and you will not get to call or cross-examine any witnesses. Do you understand that?
Yes, ma'am.
Sir, has anyone threatened you in any way or promised you anything to get you to give up your rights as it relates to this matter?
No, no one has threatened me.
Has anyone promised you anything?
No, ma'am. No one has promised me anything.
All right.
He's so happy to be there.
Mr. Barton, with respect to Mr. Perlman's
Ryan.
statement to me about a no contest plea, is that the people's offer?
I'm sorry, Your Honor. There was a tad breakup. Can you say that one more time for me?
With respect to Mr. Perlman's statement or question to me, with respect to a no contest plea.
No contest plea.
Hold on, I'm sorry. Is that the people's offer? No, a plea of no contest.
Yeah, the people have no issue with the no contest plea, Your Honor, for civil liability.
This is pre-Miss Ritter.
All right, then with respect to the plea, the court will allow a no contest plea to the charge of child abuse 4th degree with a stipulation as to the factual basis. Who is going to allocate the factual basis?
Mr. Perlman, you want the opportunity?
Yes, if I may, what the date in question was?
It was reported March 23rd,
Okay.
2020.
Okay. Mr. McCroy?
Well, hold on before you.
I apologize. To February 29th. February
Okay.
29th. Thank you, Your Honor. I'm sorry.
No, I was going to say before you did, I want to know. I don't want to know the date it was reported. I wanted to know the date of the alleged incident. So that's
February 29th, 2020, Your Honor. I do apologize.
that's okay. Okay, so Mr. Perlman, you may proceed.
Your Honor, does the court have a copy of the police report?
I don't, because I'm working from home today.
Okay. Your Honor, on 2/29, on February 29th, 2020, my client, a first-time parent, responded to his young child who was I believe, kept going over to the stove and wanted to send a message to obviously concerned. The child would, I believe that the child would get burned. Did slap the child on the behind, probably harder than he should have, and it did cause some redness.
Get the spoon. I got the spoon.
Mr. McCroy, you have to come in video, sir.
Oh, I got some information to. Never mind.
Yeah, please never
February
mind, because you, Mr. McCroy, you interrupting this proceeding and you should not be. Now, either you're gonna remain silent or you're not gonna remain silent. We're gonna have a trial, but you're not gonna speak. That's not how this is working. So either I'm gonna accept the no contest plea or we're gonna go with a different kind of plea. Okay, so Mr. Pearlman, with respect to the factual basis, you indicate that on that day, your Mr. McCroy is alleged to have hit the complaining witness on the bottom.
Won't happen no more.
Your Honor.
Your Honor, if I may.
No, nobody may. So listen. How to
Judge,
Oh, I'm sorry. I put myself on mute on my other thing. I'm trying to work my two systems. This is how it works. We're going to state the factual basis. That is the basis of the plea, or we're not. Mr. McCroy is not going to interrupt the factual basis for this no contest plea.
Your Honor.
And that's how it's going to work.
I apologize, Your Honor.
The factual basis, that's okay. All I want is the date of the incident, and all we need for the plea is the date of the incident, where the incident occurred, and what is alleged to have occurred. That is the factual basis I need to accept the plea. Date, place, and what occurred. Mr. Barton, are you trying to say something?
I am, Your Honor. Thank you very much. Okay, on March 23rd. Why do we have that day here? Oh, this is the report. Okay. Your Honor, so on February 29th, 2020, we had the defendant staying with the complaining witness staying with the defendant. The complaining witness went home to her mother. She had bruises on her buttocks that resembled purple or blackish bruising. The defendant stated he spanked her for only approximately 15 seconds with his hand, and there was a report filed.
15 seconds?
Charges were filed after that.
That's a long time.
And where does this occur?
Yes, Your Honor. The
2,
occurrence
3,
allegedly
4.
was at 14480 Collingwood Road, and that's in the city of Detroit, County of Wayne.
All right, the court will receive the factual basis and accept a no contest plea to one count of child abuse 4th degree. Having accepted the no contest plea, the court is going to set the matter for sentencing December the 16th, if that's a good date for you, counsel.
That works, Your Honor.
Okay, so brace yourself. I don't know if you've heard of this guy, Frankie Footloose Staples. Disorderly conduct charge during a protest, New Hampshire. This comes from Free Keen. If you haven't subscribed to him, he's got a lot of good soft sit. He's a K-Far, that kind. And also Dummy Kruger. I've been following them forever. Free Keen has this whole thing This is like 12-hour video. I gave you the final because a lot of it is just back and forth. Witnesses, we're just having fun with this. So this is him, okay, standing, looking like Seth Rollins from wrestling, and he's pro se, soft sit, just everything you could possibly think of that we like to watch and just in awe of. So let's get it rolling. This gets very loud, very quick. So let's roll.
There is statements of Sununu after the meeting calling everyone there, shut it.
So just in case you haven't heard, disorderly conduct at an executive county council meeting, and the governor was actually trying to get him out. So they kicked him out, and he's saying it was unconstitutional, all that kind of stuff. So here we go.
Down, no government types, and also
what's the next piece of evidence?
This is
What's up, Bill Rose?
an interview that Sununu gave where he made comments about the arrests.
That's not relevant to this procedure.
Of course it is, and he's the one who initiated it through the Department of Safety.
What's the next piece of evidence?
That's the next piece of evidence, Sununu's public statements. It's a public official thing.
It's not relevant.
Of course it's relevant. This is a governor, is not the head of the state police. Is he? The governor cannot weaponize the state police against its citizens. Can he? Sir? Can he? Can he weaponize you?
Mr. Staples.
Are you being weaponized?
Mr. Staples, what's the next piece of
This will be some great closing arguments, that's for sure. So I'll just use it as notes to remind me to talk about during my closing arguments. And, so we got it all. I mean, we have so many perspectives on this thing. Why can't Sununu's text come in camera for Your Honor to review?
You got it, Michelle.
And decide whether or not there is anything of exculpatory value in there. And if it's not, no harm, no foul. Same thing with Provenza's text while he was violating the sequestration order in here, texting out his phone. Maybe you should be able to look at those texts too.
Are you making a request?
I am making a request.
What's your request?
The request is for you to do an in-camera review of state police and Sununu's communications and Formella to see if there's anything of an exculpatory nature that was withheld by the state in discovery.
That request is denied.
Of course it's denied. Why wouldn't it be? So we're doing videos.
If you think you don't like what he's wearing now, just wait till you see the next court case. That's coming right up after this.
Probably. Can I, oh, sorry. I'm just trying
Mr.
to
Staples, please.
do
Do
this
not have
after.
any more video testimony.
You want me to do that after?
Yep.
Footloose, here we go.
Right, yeah, I'm ready to get up on the stand here. So, can I get on the stand?
Watch your step, please.
Watch your step. Here we go. Oh boy. Enjoy, people. Enjoy. Footloose. It's Frankie Footloose Staples.
So, what happened on October 13th, 2021? what happened was there was a second executive council meeting. Well, it really was the meeting because there was originally a meeting held at St. Anselm, right, for the acceptance of $27 million in COVID funding from the federal government to do track and trace, database, vaccine mandates, and isolation of quarantine of New Hampshire citizens, and the agreement to any unspecified requests with unlimited renewals of this program to get this $27 million in funding, right, for the COVID thing, which I had been protesting from day one. When Trump announced the lockdown, he said 2 weeks. I gave him that 2 weeks, and I started absolute defiance. And that's what I've devoted myself to up until this point. Okay? Because my business became under attack from the COVID lockdown measures from this governor. All right? I couldn't do smart recovery meetings, which is a free service that I provide. I was managing 6 other facilitators and hosts underneath me. So this stuff, all this COVID lockdown stuff that we now know is complete hoax, that the Sununu administration forced and accepted that money, okay? Sorry, I'm getting distracted, but I was been protesting. I had been arrested outside the governor's house for peacefully protesting. We got tickets. They created a law to say there's no picketing allowed out front of the governor's house during the lockdown, right? When he was running the state from his house, the state house was shut down. There was nowhere to protest. You could go to the state house all day long. You couldn't get to your public officials. We had to show up at his house. He was doing Zoom meetings there. Okay? So you better believe it. You're a public official. We know where you live. It's public record. We have a right to show up with a cannon. Okay? Like they did with Governor Wentworth, the first governor of New Hampshire. Yeah. Little history lesson for y'all. So I was at the St. Anselm thing, and that's when I found out exactly what that $27 million in funding was for. Therese Gurnell gave me this thing, and I saw the fine print about the isolation and quarantine of our citizens and all that. And that's where they had already paused, and they had a breakfast. So there was no actual meeting. It was a breakfast thing, and a certain amount of people were allowed in. I was one of the 50 people that got in. And once I found out about that, I started saying, oh no, this is crazy. And Therese was really being the louder one, because she's a female and she's not very loud. So I got the whole goddamn room's attention. Right? And I said, hey, pay attention. And then so people started listening to her. And I was also telling all those lobbyists and all these state bootlickers to lock me in a FEMA camp now. Why don't you try to do it yourself? Why don't you try to vaccinate me yourself? So the AG does a whole investigation for me saying, we know where you live, and they got scared, and they said, we don't want to continue this meeting further. So they didn't have the actual meeting, the original 27 million meeting at St. Anselm. They ran out the back door because the whole room, I was just the loudest and the easiest one to smear. Look at that aggressive guy with a beard swearing. Oh, you better believe I'm going to swear. Come try to put me in a FEMA camp and see what happens. Okay? Yeah. Fuck around and find out. So I'm protesting.
Mr. Staples.
I am watching my language. It's for emphasis. So, that meeting did not continue, and the AG did a whole investigation on my statements and everybody else's statements, I would imagine, at that meeting, and nothing was said, no threats were actually made. There was no meeting even shut down, but they were upset about that. They were really upset. Obviously, the prosecution has been questioning witnesses about it and raising it every chance they get about the St. Anselm event. So there was a lot of pushback, and the same thing at that event. It was even worse because there was like 250 people outside, and they allowed 50 people inside. Right? 50 people for a public meeting where they're going to vote on $27 million of funding that could put us into isolation and quarantine. All right? Potentially forced vaccination of an experimental product. Right? So, yeah, better believe I'm going to push back on that, and I'm going to show up to the next one. And I did. And we showed up to the 1013 Executive Council meeting held at the Police Standards and Trainings Facility, right? And we also knew that it was going to be a setup, that they had all the vans ready. They were ready to arrest everyone. I was actually warned and seen screenshots and told by Don Bullock. That's why Don Bullock stayed outside. He was afraid to go inside because he was in the police academy training at the time, and he was told that people were going to be getting arrested that day. Don't go inside.
Hearsay about what other people are telling folks. I think that's invisible.
I can put the screenshots.
But they just let him go.
That's fine. I mean, the screenshot's already out there anyway, so. But the point is, people knew. Law enforcement was warning us, because there is some good law enforcement. There are some good ones out there, 100%. I'm not an all cops are bad kind of guy. I'm not a shut it down government kind of guy. I'm a 10th Amendment center guy. I'm a 9th and 10th Amendment and the New Hampshire Constitution kind of guy. Article 10 kind of guy. Okay?
Thank you.
That's who I am. I'm the guy who's about the rule of law. I'm the guy who actually sued this state of New Hampshire in federal court and won pro se on constitutional violations. That's the kind of guy I am. All right? I was held in solitary for 5 years, and for refusing to shave my beard on religious grounds. That's the kind of state that we're dealing with. Okay, so those are my credentials on the law, and that I'm not a shut it down kind of guy. I'm about the rule of law, 100%. Okay, so there's the nullification of unconstitutional laws, but here we are at this thing. And we saw, and you can see in the video where Teresa's plan is to, turn our backs, link arms, pray together, and all that happy stuff, right? And I was like, that was my plan. I'm going to be quiet. I know they're going to be gunning for me because of the St. Anselm thing. And I was quiet. I mean, did I say a couple things here and there? Did I have some normal outbursts and murmurs like people do when they have it? When they're shocked about something? What, you're not allowed to breathe? Like, are you going to start arresting people who have Tourette syndrome because they tweak out during a public meeting? I mean, where do we draw the line here? And why wasn't anyone asked to leave? Why wasn't I asked to leave the first time? Why wasn't I asked to leave ever? Right? They made it seem, they told me they just wanted to talk to me. They tapped me on the shoulder. We'll try to go forward, but yeah, we sang the Pledge of Allegiance. The whole room sang it like like it should be some. And the governor said that was a disruption. You can't sing the Pledge of Allegiance like that. You can't have enthusiasm and patriotism for your country. That's not allowed. Okay? It's a little bit, I mean, I can't even believe you guys want to know why I'm so upset about this. It's no disrespect towards you, sir, in the court at all. I trust judges. I hope judges follow the law, the letter of the law. There are definitions for things. There's an order to things and how things are. There's a process. Things shall be done in certain time frames. But when the state doesn't do those things, doesn't matter. They don't have to be here on the day of prosecution. They don't have to give a complaint on the first day you show up. Apparently, they get free passes on all these timely things, but I don't, even though I am legit disabled with head trauma and a fucking goddamn mess. I can't remember. I walk back and forth. I can't remember anything. I have the worst short-term memory in the world. So, and especially with all this stuff, it's impossible for me to keep track of without assistance. And I have to thank Roseanne for doing this and helping me out a lot. I wouldn't have, but anyways, point here is, I'm being charged with recklessly clapping loudly and saying shut it down. But we don't know when.
Yeah, I'm sure.
I don't know when and what do they mean. Are they talking about the shut it down right after I was pulled out? Because I'm also charged with recklessly and purposely saying shut it down. I'm being charged with recklessly doing these things and purposely doing these things in separate counts. So it's like, it should just be 2 counts, in my opinion. But they split it into 4 counts of disorderly conduct for 2 instances. Right? Is that not stacking charges?
Mr. Staples,
So,
do you want to testify?
I am testifying about the case. And about, yes.
Then please go ahead.
So, the whole thing is a conspiracy. And he, O'Leary, has admitted and given evidence towards that fact by his questioning. The questions he asked that he's interested in that aren't even relevant to the case show the entrapment and the collusion and the conspiracy. Why does he care about the St. Anselm thing? What does that have to do with this instance? Why does he care about the DHHS Vax Pass thing? Because it's about the vaccine shill agents. These guys work for the freaking vaccine. They're part of the goddamn cabal. I'm not a QAnon guy, but these guys are part of that whole cabal, the deep state, right? They're cleaners. They got called in to handle something that none of the state police want to touch. Where are they? Where are they? Right? They didn't even file the charges. O'Leary had to file the charges. O'Leary wasn't there that day. I want to call him as a witness because he's the one that filed the initial complaints in this case. But I didn't find that out until after day 2 of the trial, I believe. Right? It was after day 2 of the trial is when I found out the prosecutor filed the original charging documents. Wow! Wow! I know. Yeah, you guys should look very, very disappointed and guilty over there.
His shirt says Footloose.
Fiddle with your pages. So, this whole
gets
thing, they even admitted, is about targeting me for these prior instances where I didn't do anything wrong. AG did a 6-month investigation into the whole, the St. Anselm thing and said that it's all free speech. And like, why wouldn't any of the troopers have arrested if I was disorderly or doing something? Why wasn't I arrested? I would have been charged and arrested. So they're just mad that people are exercising their rights and going against the things that are lining their pockets and their friends' pockets with this COVID money, right? Because they get to create positions for their friends to suck up all that money. Where did all that money go? That's what the question is. All this stuff needs to be FOIA requested. Sununu's phone records need to be in the state police on that day. He was texting during a public hearing. Hold on. Go ahead. Say what you want to say, Shepard. Let's go, deep state guy.
We've gotten pretty far afield from the facts of the case.
Oh, have we? You think you would like that's not true, though.
Mr. Staples,
I have evidence to support the targeting of all of my First Amendment activities. They created a law in Newfields to make picketing illegal in a residential neighborhood. But you know what happens with that law? It's unenforceable. People can get tickets all day long and then take it to court, and then they get thrown out or they get found not guilty.
Mr. Staples, do you have testimony that's relevant to the charges that are pending?
Yes.
Please go ahead.
Thank you. That's what I'm trying to do. So, like I said, I'm being targeted by Sununu and his administration and A.G. McDonald. So this is how deep this conspiracy goes, and we're getting it on the record. A.G. McDonald at the time is the one who contacted Newfields Town Police to get them to create the picketing ordinance to target our protests. This is about free speech, and this is about my defense, and I'll keep going. So you can object all you want.
A.G. McDonald may or may not have to do.
You haven't let me finish.
I'm here in court to deal with a prosecution of a case for events that happened on October 13, 2021. And at this point, this is really not relevant at all to that.
You don't think it is, and that don't matter what you think.
Mr. Staples.
Because this is my testimony that I'm providing, and I'm asking myself, sir, why do you think that there's a conspiracy against you and a collusion, and what evidence do you have to support that? Hold on. Sir, the state is asking about all these previous protests. The state has opened the door to going to other things that aren't relevant to this case.
But you just testified about the St. Anselm.
Correct.
You brought that up.
Because the state did.
But you said it was important to understand
this
case.
Yes. This all adds to the entrapment defense. These are all relevant facts to the collusion and conspiracy and official oppression by state actors, Governor Sununu, and actors in the state police.
I appreciate your argument, but what facts, what testimony do you have to offer in this proceeding that makes
it's on the screen.
A matter at issue in this more likely or less likely to have occurred?
What do you call everything? All of the whole history of it. Because they thought that the St. Anselm and the DHA, all these other things, this character evidence and the previous history of our protesting against the vaccine stuff.
This is this year.
Right? That's the reason they've even admitted, but it goes further back than just those things. Because we didn't even get into the DHHA's past hearing. I'm not even going to touch on that. I don't have that video. I don't want to get into all that one. But I could because they brought it up. Right? So, but I think what's important here is these facts and I'm going to be very concise. A.G. McDonald, he's now what? Supreme Court Chief Justice McDonald, who never served on a bench, was the AG at the time, who was also Sununu's personal lawyer at one point.
Okay, so now I am going to go to his last. This is the last hearing, the last day, and this is how I found this. So this is recent, a couple months ago. If not that, I'll fact check that for you. But this is very recent. So here we go. This was actually posted 13 days ago, I think. So, all right, here we go. And this is the cream of the crop. Here we go.
Staples.
Footloose!
When we concluded the
Let's go.
proceedings last time you were on the witness stand.
Yes, sir.
So, why don't you please head back up? You're still under oath, sir. And with respect to
With his shirt.
your motions to dismiss,
I wanted to file it after my testimony. I don't know if that was the timely time to file it or not.
What is he wearing?
Then I filed it before, and so it was untimely. I don't know if we can wait until after my testimony, if that's the proper time. When would be the proper time to file?
no, I just, with respect to your motions to dismiss alleging procedural infirmities with respect to bringing the charges and bringing you to trial, those are denied.
The prosecutor filing the initial complaints, and then this guy not signing on as an appearance until months after the arraignment, where Prosecutor O'Leary swore that he was here on this case on the arraignment day when he was not.
And Mr. Staples, to the extent that you want to move to dismiss at the conclusion of the case, you certainly have every right to do that.
Okay. And I did not submit this as, this was the videos that we watched. And
Somebody actually brought DeSanto's chair into this hearing. That's just DeSanto's chair.
these are the timestamps.
Any objection to those coming into evidence?
I don't have a limited amount of time to review the timestamps. So to the extent that the timestamps
Correct, Mike Crazy.
don't correspond with the court's recollection of the events in the video, I trust that the court's recollection prevails. That's all I can say about that.
Yeah, I mean, the state has said that the video evidence is the best evidence. And so if there's anything in these timestamps that does not correlate with the videos, then obviously it's a typo or whatever. But this is all correlation of the video timestamps.
I did notice there's a couple of what one might characterize as arguments captured as part of the timestamp. And I would move to exclude those sections of the exhibit.
I would just say don't take them as arguments. If you would, these are, I'm doing the best I can here. I'm burning the candle at both ends. I'm in the middle of moving. I'm homeless right now, trying to deal with this case. And then they also keep trying to ram that 254 case down our throats. We're actually supposed to be doing the 254 case right now, 12:45. I got a notification last week that we're going to be doing that case at 12:45.
Okay, Mr. Staples, I'll accept those matters into evidence with the provisions.
Thank you, sir. And another piece of exhibit that I would like to get in, this was part of the discovery. This is a public statement made by Sununu about the arrests of that day.
Well, sir, technically, what's happening right now is you're on the witness stand.
Right, and I'm
if you want to introduce something else after your testimony, I'll give you the chance to argue.
Well, I was trying to talk about this on the stand. I was actually talking about some of this stuff. with the whole entrapment and how it goes all the way back to Sununu's house protests, which he actually mentions in his public statement about the arrests.
Well, let's address it if it comes up. So please take a minute.
Thank you, Craig. Much
Should I
appreciated.
bring anything up there to help me remember stuff? Or, because I have no idea where I was. Where we left off. I don't know if you know where I was.
Oh, hang on.
Oh, baby. He has a baby Bjorn on. It's carrying him. Look at that man bun. Oh, baby. Look at him. He is ready. Oh, it gets nutty.
You know, for the most of your testimony, you were presenting 2 hours and 35 minutes of video testimony. And then you were talking about he should know, and you said you definitely clapped. And then you were talking about you wanted,
I said I definitely clapped.
yeah. And then you
What
were
I said.
talking about, I said, define that conduct.
Yes. Yes. So, thank you, sir. So, this was right before I got the warning from DeLuca, is when Sununu was talking about all these immigrants that were in the state and all this money, and people were asking how many immigrants are here in New Hampshire, and he was like, I don't know. And I said he should know, because he should know. And that's a political statement. It wasn't meant to disrupt, and that's not even what I'm being charged for. But I did get a warning for that, right? I got a warning for saying he should know, even though we saw in the video there was all kinds of people making all kinds of comments throughout the whole thing, and clapping at various points. So it seems it's appropriate to clap when Sununu says it's okay to clap, right? But when he doesn't think it's okay to clap, we're not allowed to clap. So then, from that point where I said that I would be asked to leave the room, or whatever, I honestly don't remember what he said. And I said, it's fine. And then another officer actually came over to try to say something to me. I said, he already talked to me about it. Okay? Leave me alone. I was the only one to get singled out that day for any sort of admonishment for a normal murmuring or exclamation of the events of that day. There were all kinds of people who said amen at various points. Some people said, we will be here, we'll keep coming back. None of them got warned, and none of them disrupted the meeting either. Nowhere was there a disruption or a pause in the meeting when I allegedly said any of these things, right? And I'm being charged with what? Saying, shut it down. The state has not provided any evidence that I said shut it down. This is probably closing stuff, so hold on. So, after the initial warning that I got, probably, I don't know, within an hour or so, Megan Walsh came out and she stepped out randomly while the meeting was still going, and she gave a general warning to the crowd not to make any more disruptions, even though there had not been any disruptions and the meeting had not stopped. So she gave this blanket warning out to everyone, not a particular person. And that was to try to justify the arrest that they had been planning this whole time. What is it? I couldn't even hear it.
Well, I'll give it away some time.
Yeah. So, what did I just say? I don't know why. So, yeah, I forget what I was saying. So the name loss warning, and so yeah, the name loss warning was just, it was not a lawful order, obviously, and the meeting continued, and
Thank you, Pete.
we got to the point
Richard.
where they were talking about the 27 million, okay? And the plan for us was not to disrupt the meeting. The purpose was to still express ourselves as best we could without disrupting the meeting. And so how we were going to do that was to stand up and turn our backs to the executive council to
Lisa!
let them know how many
Thank you,
people
Lisa,
supported or did not support this. And as we saw in the video, it was about 95% of the room stood up, turned their backs, and linked arms, quietly and silently. Okay? And while we were doing that, we could see in the video Sununu texting with the state police, and the state police doing their getting together before Therese said amen, and before I allegedly said yeah. We were still standing, and the cops were getting ready to do something. They were getting ready to arrest us for having everyone stand up and turn our backs. They were going to call that a disruption. That's what they were going to do. But they didn't. They instead changed the charges because they knew if we arrest them too for standing up first, then we're going to have to arrest the whole room. And it wasn't a disruption.
He says
so
room.
We all had our
Daylight.
backs turned,
Membership.
and Councilor Gaida started to push back on the acceptance of this money. What is it? Gaddis.
Sorry. Ma'am,
I'm sorry.
I can't allow you to do that, okay?
Yeah, I'm sorry.
Because
His mommy's helping him.
remove, you're here under special permission
Yes.
because of an accommodation being made to some state laws. But
Yeah,
you're not allowed to coach him from the table.
Well, she's supposed to be helping me remember stuff and stay on point. That's what you agreed to.
Oh,
She's
yeah.
helping me stay on
Your
point.
Honor, I apologize. I
Help me
thought it was
remember.
important to correct the person that was, to identify the correct person.
Yeah, but let's just establish.
Yes.
Sure, so I'm sorry, and it is what it is. So, whoever it was, I don't know these people's names. Like, they expect me to know who Provenza is and who all these people. I don't care. You guys aren't that important. So these executive council members, I don't know them by face. I don't even know them by name. So, whoever it was,
Ma'am, take a seat. You're not allowed to.
she's not allowed to stand.
She's not allowed to stand and take video or still images.
Why not? Where does it say that?
Mr. Staples,
Where does it say that in Rule 19?
just establish that if you've been granted permission to record this event, you can do so from a fixed position in the
He's
courtroom.
getting
But I
ready.
can't have people moving about the courtroom taking still or video images. You understand? Please clarify, Mr. Staples.
All right. So, the executive council member, whoever the hell it was, started to push back against the accepting of the money. And at that point is when everybody was like, oh wow, we're getting some support. The executive council is listening to us. So let's show our support and we'll turn back around and take our seats. Okay? So that's what we did. We turned back around, sat down quietly, and there was further pushback on the acceptance of this money, and the crowd erupted. I would call it an eruption, but the crowd was happy, and some people said amen, and whatever else they said at that time. And maybe there's some clapping in the video. I believe you can see me clapping. The whole room is clapping, right? Sure. Yeah, I was clapping. We also clapped when counselors or people were like sworn in and accepted into these positions. Everybody was clapping even super loud at those points, but those weren't disruptions. Those were all normal times of the meeting to show our support. How else are we supposed to let them know whether or not we're with them or not if we're have to be completely silent? There's no law or rule that says we have to be completely silent. And in fact, the Constitution allows for us to say whatever we want for political speech in either house of the legislature, Article 30. And it cannot be that the impetus for any complaint or action in any court anywhere whatsoever. So Article 30, amen. Article 30 protects us and, okay, the right to worship. We have the right to worship, and if somebody wants to say amen at a certain point because they are worshiping their fucking God, they can. You better believe it. Mr. Staples, nothing. You want to hold me in contempt? Let's go. Please watch my language, nothing. Okay? Free speech, exactly.
Sir, did you just say something out loud?
No.
Who said freedom of speech?
Who cares? Don't answer. You don't have the right. Nobody has to listen to this dude. Don't play along with his game.
I'm just going to announce that if I hear anyone say anything out loud from the gallery, I'm going to have to remove them.
For what?
Please proceed.
For what? What are you going to have them removed for? What's the rule on that?
Mr. Staples, please proceed.
Yeah, because you don't have one. Article 30 protects these people. And Article 10, the right to revolution.
Mr. Staples, please proceed.
I am proceeding. So, I can't even keep track of where I'm at because you keep disrupting the meeting. Yeah, I know.
You're laughing.
Right?
I made him laugh.
Yeah. So, I'm trying, sir. Please.
This is a joke.
So, where was I? Clapping. So we were sitting down, and people that were in attendance were happy that the executive council, some of the executive council members were listening to obviously our previous emails that we had sent and everything, and they were pushing back against the acceptance of this money. And nobody was singled out and warned for saying amen. Nobody was tapped on the shoulder except me and Therese, right? And I was tapped on the shoulder, and they said, "Come with me." I said, "Okay." So I got up, I complied, I came with them, left the public meeting, and went into a completely separate room where there was 50, what they testified to was 80 plus state troopers and sheriffs and state agents whose intentions there were to arrest every single person that was allowed in. That's why they had all the chairs zip tied together, and they didn't use that place to accommodate all the people, because there was only a certain amount let inside, and there was a small cordoned off section, which I call the kill zone.
Anybody that was in the kill zone was subject to potential arrest. Because anybody outside, they had all these friends of the politicians, and all the reporters were kept in a separate area. That was not the kill zone. Much bigger area.
What's up,
3 times
Obey?
the size is the small area where they only let in the amount of people that they had seats for in the paddy wagons. 8 paddy wagons times 16 people equals the amount of chairs that people were allowed to attend this meeting from the protest. They planned on arresting everyone for saying amen. That's what they planned on. And the state said, oh, we're there to protect the elderly and to protect the children, right? It was all to protect the elderly and the children. Then why did you guys arrest women with babies in their arms? I saw women with babies in their arms getting arrested, and women, old women, 7-year-old, smashed her head on the concrete, dragged her out, manhandled her all the way out, and then smashed her head on the concrete because they were protecting the elderly, right? No, they weren't protecting shit. They were following orders like bootlickers for Governor Sununu. Okay? This was all orchestrated by the Executive Council. We even heard Megan Rose say that, oh, it was picked, that location was picked specifically by the Executive Council.
Mr. Staples, do you have any further testimony about this?
Yeah. I'm about to start talking about how I said shut it down. Okay? Are you going to just stop me from testifying? Are you going to try to rush me? Or are you going to let me testify? It's not your fault. I am proceeding. Stop fucking disrupting my goddamn train of thought. Okay?
Mr. Staples.
What are you going to do about it? Nothing.
Yeah.
Stop!
Please proceed.
I told you.
So, as
You know he yelled at him just because he stopped his train of thought. Stop yelling at forgetting my train of thought. That's
I'm
yeah.
made to seem like we're being asked to leave, which is what Sununu testified to, or said to the crowd, right? The chief executive, the supreme excellency of the state of New Hampshire, His Excellency said, you will be asked to leave after Megan, this was however long it was after Megan Walsh's warning for whatever she was warning. She said, you guys will be asked, people will be asked to leave if there's a disruption. And I thought maybe I'm being asked to leave. But when I get behind the curtain, they said, oh, you're under arrest. I said, I'm under arrest for what? Disorderly conduct. Oh, all right. I didn't protest. I didn't fight. Once I was in cuffs and I was under arrest, you better believe I'm going to say something about it. And I started yelling, shut it down. We're being arrested. Fuck this shit. Because I'm hyperbolic. That's how I am. Right? And if you want to call that whatever it is what it is. I said it. I'm protesting my goddamn arrest. And I will protest my arrest. Did I fight? Did I resist? Did I get charged with resisting? No. It's not my fault that the police arrested me inside this other room that was not part of the public meeting, a completely separate room, right? Why didn't they take me outside the building? They knew I was going to be loud and they thought it might disrupt the meeting. Why didn't they ask me to leave? Like Sununu said they would ask me to leave. I don't know. Sounds like entrapment to me. But anyways, I was arrested, and once I was put in cuffs, you got
What's up,
said. Okay? And that's not true. We're constitutionalists. We believe in the rule of law. The real law, where you guys get all your rules and all your statutes come from the Constitution, and they come from our consent.
Bill of Rights.
So,
Did you see who said that?
No, I couldn't.
we got the murder police out there.
But I was a little what?
Alright. So, yeah, I hooted and hollered, and then they start arresting. You know, the state wants us to believe that they're protecting us and protecting the citizens, but they weren't protecting nothing. They were protecting the governor. They were protecting the governor, and they were protecting that federal pimp money, because they're whores. Nothing but whores.
All right, do you have any further testimony?
Yeah, I do have further testimony. So, I also refuse to sign the bail conditions, because that's coming up in the next case. I refuse to sign those bail conditions. It's a non-jailable offense. You can't even detain me. You can't even detain me if I refuse to sign. So, I got into the van, and other people are getting arrested for asking why we're getting arrested, and it was terrifying, absolutely terrifying to watch what happened after I was arrested. Despicable. And
Thank you, Pup Mom. Pup Mom, are you a nurse? My mommy was a nurse. God bless you if you are.
sorry. Oh yeah, you guys, let's go. Let's get this shit show started.
Thank you, Chris.
Who's up first, Blinky?
Oh boy, now he's getting questions.
Oh, please, nothing. They drag me in, you guys drag me in. I'll do whatever the fuck I want. I'll say whatever the fuck I want, whatever the fuck I want.
Yeah!
Think that's a disruption? You think that's contempt? Fucking hold me in contempt then.
Mr. Staples,
Do it.
based on your conduct, you seem to want to be helped.
Maybe.
And
What did that hand sanitizer ever do to him? Come on.
Maybe
Come
it's
on.
part of my disability. You want to hold me in contempt for my disability? Fuck you. You do it. I dare you. You already acknowledged it. You've already seen this shit. This is how I am. This is my normal baseline. Everybody knows it. A lot of people hate it. They like me, but they hate when I get like this. Just like you don't like it right now. But it is what it is.
all right, Mr. Staples, it sounds to me like you're recognizing that you're getting a little bit carried away. So let's try to get through this.
Do you want to take a 5-minute break?
Do you feel like you need a 5-minute break?
Maybe, yeah.
All right, so let's take a 5-minute break.
All right, thank you.
We don't take a 5-minute break. We come right back.
My camera keeps going off.
All right, Mr. Staples, come on back. You want to go ahead?
Oh boy! This is the last gasp for Mr. Footloose. Frank Footloose Staples. They all had a timeout and a cookie And then now, they watched Elmo talk about their feelings, and now we're back. Brace yourself. Look at the judge. This poor judge.
Thank you. Mr. Staples, with respect to your behavior, with respect to that particular day, you do recall at some point in time the governor gave a warning after the Pledge of Allegiance, asking people to be quiet. Do you recall that?
I don't recall him asking people to be quiet. He said, people, if there are any more disruptions or outbursts like that, then we can't have that or something along those lines. He didn't say, people, you need to be quiet, you have to be silent. If anyone says anything or makes a noise, you're going to be arrested. He didn't say anything like that, no.
And you recall...
And is he law enforcement? Is that a lawful order by Sununu?
What would you say
it's a lawful order?
Would you recognize?
No, it's not a lawful order.
Would you recognize the trooper who stood up in front of you and said, "We're going to need to be quiet"? Would you recognize her as law enforcement? Megan Walsh.
Megan Walsh did not give me a warning.
Would you recognize her as law enforcement?
Sure.
Okay.
But that was not a lawful order.
How about Sergeant DeLuca, when he came up and came down and spoke to you and asked you to be quiet? Would you recognize him to be law enforcement?
Correct.
Okay. All right. So with respect to him giving you a specific request based upon conduct that he had observed, you recognize that he gave you that request based upon being law enforcement.
What request?
That he came up to you and told you...
What did he tell me? I don't know what you said. You're the one saying what he told me.
Yeah. He came up to you and asked you to be quiet.
I don't know. I don't remember exactly what he said.
Okay, we can testify, so we'll take him as...
Sure, take his testimony, whatever you want to do.
So with respect to...
There's no nexus to the arrest.
Did she also inform you and the rest of the people there that further disruptions would lead to people being arrested for disorderly conduct?
What are you talking about now?
Did Ms. Walsh, did Sergeant Walsh say that to you?
She did not say that to me, no.
Did she say it to the group?
She did not say it to any one person.
Okay. She said it.
Hold on. I'm answering your question. She did not say it to any one person, which is what the law requires and references. It doesn't allow for a blanket statement. So let's say 10 people in the room make some disruptions or say some things, and then she comes out and she warns the entire crowd, and there's 100 people there. 10 people made noises that she came out maybe. She also testified she doesn't know why she gave the thing. She don't even know why she came out, so she had no purpose. She was ordered to give that. So it can't be a lawful order from her.
So after an individual request from Sergeant DeLuca and later a general request from Megan Walsh,
I didn't get a general request.
I'm going to make sure that he doesn't interrupt you answering. Let me ask you to not interrupt his question. Wait till he concludes.
And with respect to the proceedings after that, at some point in time, they started to discuss some things, and you said we had a plan, or we had all agreed that we were going to stand up and turn our backs to the state.
I did say that.
Yeah. And during that period of time, when Councilor Gatzis apparently said something that you and some of the group agreed with. You recall Terry saying, amen, and you recall saying, yeah.
I did not say that, no.
Right.
I said that your troopers testified that I said yeah,
Right.
and that's why I was arrested.
Right. And
Yeah, and hold on. I wasn't actually charged with saying yeah. I was charged with saying shut it down.
And certainly after you had uttered something, after
Something?
Teresa had said what she had said, you then ended up clapping, I believe you testified.
In the video, you can see the whole room clapping, yeah.
Okay.
Everyone
And
clapped.
so it was after the specific warning of Sergeant DeLuca and after the general warning from Ms. Walsh, specifically saying obstructing the meeting will lead to arrest, that you engaged in the conduct that we're talking about. Those things are happening.
I don't know what you're talking about because you're being just as vague as she was with her thing. If there's any more disruptions or she didn't say anything about clapping. She didn't say nobody's allowed to clap at certain points in the meeting, did she? She didn't say everyone has to be completely quiet and silent or you'll be arrested, did she? No, she didn't.
And earlier you said that you're allowed freedom of speech, and you referenced, I believe you referenced, our state constitution.
Article 30.
Article 30, right?
Article 30.
So why don't we look at Article 30?
I've already looked at it.
Okay, let's do it together.
Oh, let's do it, because you're probably the first time you've ever read it.
So, freedom of deliberation, speech, and debate in either house of the legislature.
Sure.
Right? Were you in either house of the legislature? Were you in either house of the legislature when this was occurring?
This was legislative stuff. This is
Were you
business.
in either house of the
It
legislature?
couldn't be held there. How could it be held there? In lieu of being held at the State House, it was held there. So it doesn't matter. At that time, where that meeting was being held is state property, is part of the legislature. So just because you held it off-site somewhere to entrap and arrest everybody and not have it so that everyone could be in Reps Hall, like there was just a meeting last week that everybody was allowed in Reps Hall that holds 400 plus people. Okay, the police standards and trainings could have held 400 people, but you guys cordoned it off and only let in about 150 or whatever.
Are you saying the governor and council regularly meets in Raps Hall?
I don't fucking know. You think I follow this shit that much, dude? You act like I'm some fucking goddamn politician.
How is
Well,
this
I mean,
going
this guy
on?
acts like I know everything and everybody and all the processes, all this shit. My purpose was to not get FEMA camps, isolation and quarantine put in this state by accepting $27 million in federal pimp money.
Okay.
Okay?
And with respect to our state constitution, there's a provision that deals with council. Can you tell me where in the provisions there where it talks about council?
No, I don't know what you're talking. What's the
Where it
point?
talks about freedom of speech at a council meeting? Do you see anything in there about?
Article 22, freedom of speech anytime, anywhere, any place.
He threw it out.
Yes.
I can't.
Can I ask you to direct your questions to address
Ooh.
the conduct that's alleged in the complaints?
Okay.
Yeah,
I mean, he's
yeah, address what I'm being charged with.
alleging that he had.
You're saying I said yeah, and I'm not even charged with that.
Mr. Staples,
Oh, but I mean, this is insane.
I understand that you represented to the court that your disability makes it difficult for you to enjoy.
I even took Xanax today. It's not prescribed. So I'm super as calm as I can fucking be, dude.
All right, well, just
He just said he took Xanax. I didn't hear this, guys. This part I didn't see. Oh boy.
I'm trying. This guy's. Oh, you said yeah, but I'm not even charged with saying yeah, and I wasn't arrested for saying yeah. So what the fuck is really going on here? I don't understand. He don't know what's going on. Look at him blinking again.
Do you have any further
Look at
questions?
him blinking.
I guess the only other thing I would like to do is I'd like to ask him about whether or not his intent was to go and to disrupt things. And he said earlier that he wasn't there to disrupt things.
Correct.
And I want to play him a bit of video to show exactly what his intent is. Do you recall going to the governor and council meeting down in...
Council meeting was held at the New Hampshire Institute of Politics in Manchester.
Shut it down, motherfucker! Shut the fuck down! Shut that shit the fuck off! This has nothing to do with this case! Nothing! I'm not being charged with anything there! He's asking about that thing? Yo! The fucking AG did a 6-month investigation on that and said nothing happened! Okay? Why wasn't I charged with anything there?
Oh.
Why wasn't I charged with anything there, you fucking cunt? Huh? Fuck you!
Your Honor, essentially, all I wanted to ask him was because it's the state's burden to show purpose. I wanted to show this and ask if that was him, and ask if he had, acted that way, such that the state police were on notice with respect to his conduct at these meetings. Beyond that, especially considering his behavior, I don't expect that I'm going to ask him any more questions. I was going to ask him about some things that happened behind the curtain after he had been removed from the room. At this point, I don't have him available to ask him those questions. I suppose we could just rest on what the court has seen and had the opportunity to view. With that, I think that the state will rest at this point with respect to these charges. If you would like me to make a brief closing statement, I could do that.
Yeah, I'm going to give everyone, ma'am, I'm going to give everyone a few minutes to prepare a closing argument. I'm going to give you the chance to go out and speak with Mr. Staples. If
No, child.
you think
See that? Now I gotta look it up. You know I'm gonna look that up.
state where he'll agree to.
He's coming right back, people.
Then let's have him back in the courtroom so that he can.
Your Honor,
Judge lets him back.
Patricia Jorgensen was, the state was cross-examining her, and then she wasn't here for the last hearing, but she didn't know she was supposed to be here. She is here today, but the state was cross-examined, and she still has, they can ask the same questions with regards to, has she watched anything, has she talked to anyone? We were not aware that we had no way of getting in touch with her, and the state had presented that they wanted to continue cross-examination, but they never provided that information to her. So we would just like to be able to have her come back in and continue with the state's cross-examination so that her testimony of almost 45 minutes was completely stricken from the record.
This judge is horrified.
I understand that these are lay witnesses and lay people presenting cases, so there might have been a misunderstanding.
Yeah, there might have been a misunderstanding, and to whatever extent Mr. Jorgensen has relevant testimony, I think it's cumulative at this point. And
they asked to cross-examine her, and you actually excluded her testimony in its entirety because she wasn't here. So at this point, we'd like to have the opportunity for them to finish their cross-examination and her complete thing to be put back into the record.
And respectfully, that request is denied.
Okay?
So I'm going to take a brief recess and let's bring Mr. Staples back to the courtroom. He's able to conduct himself reasonably.
Mr. Gambini.
All right, please.
Inside a baseball player. It's not admissible. So do you have any other evidence or testimony that you want to
Yeah, just this piece here.
What is that?
This is part of the state's discovery, and this is Office of Governor Chris Sununu press conference from Wednesday, October 13th, 2021 at 3 o'clock. And he makes statements in here about the arrests.
Why is it relevant?
It's relevant towards the entrapment defense building, into where his statements that he makes proves that it goes all the way back to the protest in front of his house, and that he's targeting everyone in the entire room. He admits to it in his own statement. They're evidence. It's part of the discovery.
Your Honor, it looks to me to be a transcript of a press conference held after the events with a declarant who is not in court to be cross-examined. I don't think it should be accepted by the court.
That's why I wanted Sununu here. We need to be able to cross-examine Sununu's statements and what they are putting forward from Sununu.
He wanted the governor there. The governor to testify. He's tried to subpoena the governor. I can't.
And then why is this part of the discovery if I'm not allowed to use it? And there's relevant facts in there, statements, public statements in his official capacity that he made about the arrests.
The state's objection is the same. Any other evidence or testimony you'd like to introduce?
Oh yeah, I wasn't here for the Pat Jorgensen thing. Why is she not being allowed to finish her cross-examination?
I have ruled under Rule 403 that it would be needlessly cumulative at this point.
Needlessly cumulative? No, but her testimony's been stricken only because they were not allowed to finish cross-examination. So it's not the cumulative, it's already happened, now it's being removed. Her testimony was some of the best testimony that we had.
That's the court's decision.
Oh, it's the court's decision to keep it removed. So, okay. And what about, I'd like to call O'Leary to the stand. Because he filed the original complaints. I want to ask him about the original complaints that he filed.
Yeah.
Why does he object?
I'm not witness to the underlying case.
You are a witness.
And under court rule, one cannot be both an attorney in the matter and a witness in the case.
Right. You can't be the prosecutor and the complainant, but he is.
Mr. Staples, do you have any more evidence or testimony?
This, yeah. Him being the complainant and the prosecutor, which he just admitted is not allowed.
Do you address it?
No, what do you mean? Can I enter this as evidence? It's part of the court record.
It's a part of the court record.
So it's already, you already know what it is, right? And Shepard didn't file his appearance until way after as well. So what do you mean, if I rest now, then I get his closing arguments? Okay. Yeah, certainly. To rest. Rest, okay. Yeah, so should be good to go into closing arguments here.
Please go ahead.
So, yeah, that's fine. So, the state has clearly not met its burden of proof, nor have they provided accurate evidence that I committed the crime of disorderly conduct. They presented clips of videos that were clearly doctored and amplified, that were different from the full context videos that I showed of the incident. And due to the wide range of inconsistent and irrelevant statements surrounding incidents of 1013 arrests from the state's witnesses, and the lack of video evidence that demonstrates I was guilty of the crimes I was charged with, the only consistent feature between the troopers' testimonies, who've now left the room, was that the entire day had been carefully orchestrated between the state police, the governor, and the executive council. They picked that location specifically, and Megan Rose testified to that they had to pick that because it was not a normal type of it was not a typical event, right, where there's only a few people showing up. This was a very serious event where there was hundreds and hundreds of people trying to attend and protest and not get this money for FEMA camps and the isolation and quarantine of New Hampshire citizens that was strings attached to the $27 million of funding, right? So the entire day had been carefully orchestrated by the governor and executive council with over 80 state agents and up to 8 paddy wagons ready to arrest a small segmented portion of the public who were known to have come up against Sununu's saying that this money had to be accepted. We're going to get this money accepted. It's all disinformation with the vaccines. These people are conspiracy theorists. They're not members of the GOP. They're not Republicans. And a lot of people maybe aren't. A lot of people are probably independent. But what does that matter? Right? What does that matter? The state provided discovery regarding this press conference that was held on 10/13, and Sununu was quoted as saying, "Look, I believe most of the people standing in the public in that room protesting were not part of the Republican Party. These are anti-government, shut it down, no government at all cost type individuals." I mean, they've been fairly blunt about this, frankly.
You know, on the trier fact here, can you just address your argument to me and not wander around the courtroom and speak to
One, I mean, I'm right here. It's like at 2 feet. I'm just going back and forth.
No, just address things, please. Stop twirling around.
Stop twirling
Hand
around.
on the hip. His grandmother's yelling at him.
He's arguing the fact is not evidence. He's quoted from the governor's press conference, which is quoted in his comments.
That's the same.
Sure, whatever.
So
the folks that were at that meeting were passionately and vehemently opposed to the acceptance of the $27 million in federal PIP money that was to create conditions for the isolation and quarantine of New Hampshire citizens at the direction of the federal government. The state showed us extremely brief selected clips of what appeared to be doctored and amplified video. Who did the doctoring? Trooper Pavenza, their specialist IT guy, who I was not made aware of, that he was going to be their specialist expert IT guy. What are Pavenza's credentials? What are Pavenza's credentials for IT? Well, he had to settle for a case where he doctored.
Welcome, Lotto.
No, this is Lori List stuff.
It is absolutely not Lori List stuff.
It is Lori List stuff.
Trooper Prevented has never been placed in the Lori.
Yes, he is. He's on the unredacted list.
To the best of my knowledge, he is not on the Lori List.
He is.
Specifically absolved from responsibility in the case that Mr. Staples is referring to.
You don't know what case is referring to.
These are facts that aren't before the court anyway, Mr. Staples. You've got to restrict your...
They are before the court. I put them in my motion to dismiss.
It's not evidence that's before the court, Mr. Staples. So
how do I get it into evidence before the court? Do I have to take it off of this thing and submit it into evidence right now?
Please proceed with your argument.
So I'd like to submit that as evidence. The Lori List issues with Prevenza.
Mr. Staples, the evidence is closed in this case. This is your opportunity to make closing argument.
And you said that you would accommodate me and you should be giving me leeway. I don't understand all these processes, sir.
Mr. Staples, this court provided you with ample accommodation.
Oh, yeah,
So
sure.
please proceed.
Yeah, okay. So,
Oh, yeah, sure.
so I wasn't allowed to object to this expert witness who was also the complainant on these null pros, or on the new charges after these ones were null pros, right? And he testified, Preventive testified under oath that he was the scribe on 10/13/2021. His job was to write all the tickets for that day. So I would ask why O'Leary wrote the tickets for that day, when Prevenza said that it was his job to do that. Testified under oath. The original complaints were filed with the court on 11/5 by O'Leary. The prosecutor on this case until 4/29/2022. Note that this was more than 2 weeks after Prevenza came to rescue O'Leary and filed new charges, which he was supposed to file from the beginning, because that's what he testified under oath. His job was that day was the scribe. So the state wants us to believe all these things that don't jive.
Ma'am, were you providing assistance?
No, I'm looking at I don't have a second copy, so I'm looking at
Shut
it.
up.
Okay.
Thank you.
Oh, the judge always does keep picking on her.
So, I mean, this is prosecutorial misconduct, this whole case, and malicious prosecution, because they've not proven anything. They had troopers getting up here testifying to everything except what I'm charged with. None of them testified that I clapped at any certain point and disrupted the meeting and showed where any disruption from any loud clapping was. There's no minute marks of this supposed evidence, he keeps referring to, oh, at this point and at that point, all these very big, where is it in the video? Where's the minute marks? Because I got all our stuff marked with the minute marks. The state has not provided that. O'Leary was not at the 11/19 arraignment, despite his assertion that the court has heard, and that the court has heard testimony that Attorney Shepard was there on this date. It is true that Attorney Shepard
talking about the 11/19 arraignment here. Judge, I guess I object. I know this is closing argument.
This is closing arguments. This is all on the record. I want this on the record for the appeals. This is my closing arguments for all the stuff that's come about. I mean, what else am I supposed to say?
Well, I think it's confusing, saying the 11/19 event. It's the 11/19.
Yeah, that's not that. No, this was the 11/19 arraignment, not the 11/19 event. The arraignment that you were not at. Remember? When you said that, when he said that Attorney Shepard was on the case that day.
I think it's irrelevant. This part of the argument is irrelevant of why he's talking about this. That's not.
It's relevant, sir, because it goes to show that the state has been lying this whole time about the entire process of this case. O'Leary swears that Shepard was there on 11/19, but Shepard did not file an appearance until 3/21/2022. So how was he there that day on 11/19 for the arraignment when O'Leary was not there? O'Leary swears that Shepard was on the case that day. He was not. Okay? So I'm going to this. The point of this is showing that the state is lying and they're misrepresenting the facts, all the facts of this case, particularly the arraignment and the prosecution, and how he was the original complainant, and that's why he wasn't there that day. And they saw Shepard. Shepard was in the video of that arraignment, and right before the arraignment commences, you can see Shepard walk out, because he wasn't here on that case. He didn't sign on until months later.
Mr. Staples, I'm going to do two things. I'm going to instruct the state to allow you to conclude your closing argument, and I'm going to restrict your closing argument to another 15 minutes. So when that clock says 2, that's when I'm going to stop. So there's a quid pro quo here. The state's not going to interrupt you, and you're going to efficiently make your case in closing argument.
I'm trying. I got this up here. And you can't limit me to a certain amount of time. I'm doing the best I can, okay? I'm going to finish my closing arguments. I have it all right here. And I'm doing the best I can. So to try to say you're only allowed a certain amount of time, no.
You're allowed until 2.
We'll see. So, yeah. So Judge Staff even acknowledged that the state was absent for this initial appearance during the hearing, and all well documented and proven by the court record. In fact, the court records support that Shepard did not file his appearance until 3/21/22. Therefore, it is simply not possible for Shepard to have been on the case for the 11/19 arraignment. Moreover, the initial complaint does not show that these complaints were ever served on the defendant in hand or anything in any other capacity. The defendant contends that these complaints were not received until the time the state provided discovery. O'Leary has stated repeatedly that the complaints were given to the defense counsel on record, but again, the court records document that the counsel for the defendant did not appear on the court record until 11/10/2021, clearly because O'Leary was not present on 11/19/2021. And we have excluded Shepard as acting on the state's behalf of this hearing, as he expects the court to believe he served the documents to counsel according to the laws of the state. The court record contradicts everything that the state has professed to the court. These are clear violations of rules for due process. If this is not enough to sway the court's opinion, there is more. Article 5 protests New Hampshire citizens' right to worship. We heard testimony that I was arrested for saying yeah after Therese Grinnell said amen. Okay? Even though I'm not charged with that. And there are at least 2 others that we saw in the video, 2 to 3 others that exclaimed their praise of amen at that same time. Is this purposeful disruption? Really? Is this reckless? The officers themselves were not even sure what they were giving warnings about, or even why they were ordered to arrest us. They said they were just following orders. Megan Rose can't give a lawful order if she doesn't know the purpose of the order. Okay? A lawful order is a command issued to any person for the purpose of preventing said person, not persons, said person from committing any offense set forth in this section. When the officer has reasonable grounds to believe that said person is about to commit any such act or offense, when said person is engaged in a course of conduct which makes his commission of such an offense imminent. A command issued to a person to stop him from continuing to commit any offense set forth in this section, when the officer has reasonable grounds to believe that said person is presently engaged in conduct which constitutes an offense. Okay? So, said person, the general warning by Megan Walsh was not to any one said person, and it was not for any specific offense. You can't color 90 people in the room who didn't do anything as now you're subject to arrest if you make one peep. So Megan Walsh's lawful could not have been ordered because she did not even know the purpose. She testified that she was just told and she had no idea why she was giving the order. So it could not have been a lawful order. The only one who could give a lawful order is the one who witnessed the conduct and went to the individual, the person, to tell them that. And what is this? 644-2, disorderly conduct, section 6 says disorderly conduct is a misdemeanor if the offense continues after a request by a person to desist. That is not what happened. Otherwise, it's a violation. Okay? There was nothing. When I got my warning, I didn't continue. We ended up getting a warning from Megan Walsh, and it was a general, not a lawful order. The only lawful order I got was from DeLuca when he came, when I, way earlier in the meeting. So the conduct didn't continue, right, after that. I listened to it. So, if anything, this should be a violation. And I would argue that the citizens, I would argue that the arrests that day were intended to send a strong warning to all citizens who may not agree with their elected and appointed officials by creating a chilling effect and taking out the folks who have been previously identified as flies in the emperor's ointment from previous events, right? And the state provided no evidence that I created a hazard or that I did anything purposefully to disrupt the meeting or anything reckless, because the charges are duplicated as purposely did this and recklessly did this. How do you recklessly make a statement? How does that create a reckless or a danger or a hazard by making a political statement? All right? We had no testimony to support that there was no disturbance or disruption of the meeting until after I was behind the curtain, out of the public meeting, and being arrested. We heard testimony that I didn't start hooting and hollering until I was in handcuffs and protesting my arrest. After the Walsh warning, Sanu then told the crowd that people would be asked to leave. Instead, the meeting was paused upon my being put into cuffs and then protesting the warnings. That was the only time the meeting was paused, was after I was already out back and protesting my arrest. So where was the disruption of the meeting prior to that when the state trooper said, I said, yeah. We also heard testimony that I said, it's a lie. Yeah, this is important. So DeLuca said he witnessed me say it's a lie twice, and then that's why he ordered Greco to arrest me. But then another officer said I was arrested for saying yeah after Therese said amen, even though I'm being charged with saying shut it down. One trooper said that I said shut it down, and he said it was prior to the Megan Walsh's warning. I didn't say shut it down, but even if I did prior to the Megan Walsh's warning, why would I be arrested for it over an hour later? And how would that, am I getting arrested for something after the warning that I did before? You know what I'm trying to say? So I supposedly said shut it down prior to the Megan Walsh's warning, and that's what I was arrested for? That doesn't make sense to me, because if I hadn't received the warning that I'm going to be arrested yet, then why did I get arrested for saying shut it down? If that's when they're saying I said shut it down, which is what they did say. All the people that were in attendance that day were people of average sensibilities. These were all normal citizens. And there was all kinds of people saying amen, clapping at different points. We will be here, we'll keep coming back. None of those people got warned. That wasn't a disruption. The meeting was never paused for any of those things. As far as I'm concerned, those were all normal things that people, when they get upset or when they get happy, we're allowed to clap loudly for the people who are getting voted in and sworn in, but we're not allowed to exclaim at other points in the meeting, only at approved points in the meeting. It's very, very confusing to know what is and what isn't allowed, right? And why didn't LaVoy arrest me? Because he's the one that said, I said shut it down prior to the Megan Walsh's warning. Why didn't they arrest me right then? Oh, because Megan Walsh didn't give her warning yet. No wonder. So why am I being arrested for saying shut it down? And when did I say shut it down? There's no proof. There's no time stamps. They didn't show anything in their videos of me saying shut it down after the Megan Walsh's warning, right? The whole room said all kinds of stuff, but me and Therese were the only ones that were arrested, and they did testify that I was arrested for saying, yeah, and it's a lie, and shut it down. So, very, very conflicting statements. And these people, including myself, were arrested for asking questions that the very folks that swore an oath to protect them. More conditions which contributed to the arrest included how there were small roped-off sections and the chairs were zip tied together. All those citizens were subject to arrest, as you heard me testify, the kill zone. there was a separate area where certain members of the public, friends of the politicians, and certain media was allowed to be. Those people were not subject to this entrapment situation. If it were not for the Megan Walsh warning, followed by Sununu saying people would be asked to leave, it wouldn't be an entrapment. But given all the totality of the circumstances, picking that specific location, sectioning us all off into a small area, giving multiple warnings from Sununu, who I don't even know if he's not law enforcement, so is his warnings and admonitions lawful orders after the Pledge of Allegiance? And, you know, it's just confusing. What are we supposed to, are we going to listen to the governor saying, you guys are going to be asked to leave? Or do we listen to Megan Walsh, who just gives this blanket statement? The purpose and why she was ordered to give that blanket statement was to create the conditions for arrest. Those conditions for all those arrests, mine and everyone else there included, could not have happened without the Sununu admonitions and the Walsh warning, which is the state's whole entire case. All right, two things. So, now looking at what was going on from the time the defense turned his back until, from the time the defense turned his back, so the defendant turned his back, and he turned around and sat back down and was tapped on the shoulder. Councilor Gatsis was very clearly speaking in opposition to the $27 million. So why would anyone who was there to keep the money from coming to New Hampshire want to stop the meeting? We wanted the vote. There's also at the very beginning, right before we did the Pledge of Allegiance, I said, vote no. You can hear me clearly. I believe we showed that. But I said, vote no, right before the meeting was about to start. You can clearly hear my voice. And that's all I wanted, was to vote no. We saw in the beginning, the plan was to let them vote and see where it goes. It was not to disrupt the meeting. My purpose and everybody's purpose there was not to disrupt the meeting, was to let the vote happen. And there was...
Ma'am, Mr. Staples, you have 2 minutes.
2 minutes. So... we the people of New Hampshire, frankly, you can see by the way I am here throughout this whole proceeding, we're fed up. And we will not be silenced any longer. We will not be censured any longer. We will not be fearful of arrest for saying amen or yeah or any other pedantic thing, muttering under our breath. We will not be fearful of being proud to demonstrate our religious freedoms, and we will protect the right of all those who wish to say amen or object to anything at a public meeting. Article 30 says, if this was a house of the legislature, this was an official meeting, just because it's not held on that property doesn't mean anything. It says the freedom of deliberation, speech, and debate in either house of the legislature is so essential to the rights of the people that it cannot be the foundation of any action, complaint, or prosecution in any court or other place whatsoever. Article 31, meetings of the legislature are for what purposes? The legislature shall assemble for the redress
right? And to request the legislative body by way of petition, remonstrance, or redress of the wrongs done to them and the grievances they suffer. So if not at a public meeting, where are we to express our opposition to these things? After the fact, in the parking lot where everybody else is locked in an echo chamber, where we don't have access to our public officials to let them know? No, the time and the place is right there, right now, at the public meeting. Rights of assembly, the purpose of the meetings, freedom of speech, also free speech and liberty of the press are essential to the security and freedom of the state. They ought therefore be inviolably preserved. Okay? So this entire case is about free speech and people being able to grieve to the government and their elected officials. So I would say Article 31 should not even allow this case to go forward in any respect. I was not asked to leave, and I was still charged with a misdemeanor instead of a violation, right? Disorderly conduct is a misdemeanor if the offense continues after a request to desist. I didn't even get asked. They just tapped me on the shoulder and didn't even say what the disorderly conduct, because they didn't even know what the disorderly conduct was. Nobody knew what the disorderly conduct was. The officers were just following orders.
Thank you, Mr. Stevens.
Thank you.
The state would indicate that the evidence in this case is pretty clear. The defendant was put on notice multiple times on the day of this meeting with regard to behavior and conduct and speech to not disrupt a meeting of the governor or council. He has cited repeatedly to a claim of some sort of a First Amendment right to express himself. But what he cites to have to do with things that have to do with the legislature. They have nothing to do with meetings of the governor or council. What we indicate and what we are saying is essentially there is a reason to have time, place, and manner restrictions on speech. And in this particular instance, it was very clear. These meetings are not, if you look under the state constitution having to do with the governor, assembly, and the council, they are not participatory meetings in the sense that the public gets to go there and stand up. I know it was several days ago that we heard the testimony of Ms. Rose, but she's the person who is regularly at these meetings and reports these meetings, and there is a manner in which they proceed that is not, the public is recognized to come up and speak and address. These are situations where the governor or council recognize people who perhaps are nominated for a position or whatever, but they are not meetings at which members of the public are just allowed to show up and start talking. They're not allowed to disrupt. She said that online they have information that is available to the public to understand. We have an open government. We want people to be allowed to come to meetings and to see what is going on in the meetings. That's the nature of it. But participate does not mean that you get to stand up or that you get to make noise or that you get to disrupt. I think it's very clear with respect to Mr. Staples, but that's exactly what he wanted to do. And it's very clear that in the after he's taken behind the curtain and informed he's being arrested because he's been given an individual warning with respect to conduct. He's been given a general warning with respect to Sergeant Walsh, and then Captain Walsh specifically sees him doing things. It's like that's after he's been warned by Sergeant DeLuca and after he's been given the general warning with the rest of the crowd that they will be arrested. He is in fact identified, taken outside, and arrested. And his response is to yell and to scream. I'm not going to belabor that point, but I think it's very clear that once he has been, told that he's under arrest, his response is, now I'm going to ramp it up even more. I'm going to yell, shut it down, shut it down, shut it down. That's very clear from the information that's on the records that are before you. That's very clear from the video. It's very clear from the testimony. No question whatsoever what his intent was with respect to that. So the state is charged in the alternative and said, look, if he was doing things classically doing all the rest, he was clearly recklessly creating a risk at the very least when he was inside. And then once he's arrested and he's behind the curtain, he's not even facing the troopers that are telling him that he's under arrest. He's shouting at the curtain so that the people inside can understand, and he's communicating to them, you need to stop this meeting. You need to shut this down. That's as clear can be with regard to purpose. I would cite, the one case I will cite to the court having to do with time, place, and manner restrictions and the notion that they are reasonable, that our First Amendment is the people have a right to express themselves, but the court can also understand, and it is in fact the case, that reasonable time, place, and manner restrictions have been recognized in this state and have been recognized in United States Supreme Court opinions going back many, many years. The case I'm going to cite is the state of New Hampshire versus Bailey. It's 166 New Hampshire 537, and it talks about things about reasonable restrictions on speech. And in this particular situation, the defendant is cited to things having to do with free speech at the houses of the legislature, which I think, reasonably goes to people addressing their representatives in that forum, and it's specifically set out in our Constitution. But there's a second part of the Constitution, state Constitution, that deals with the governor assembling with council to consider things like nominations, to consider contracts before the state, to consider things like that. And under those circumstances, the public has a right to be present to see that the government is functioning a certain way, but they do not have a right to participate. And that's specifically what Megan Walsh was addressing to that. Any further disruptions and you're going to be arrested for disorderly conduct. She is clearly a lawful authority. She clearly has the right to make that pronouncement. And with respect to Mr. Staples, the court heard the testimony of Sergeant DeLuca that he had individually told him about the behavior and disruptions before. So to the extent it's charged as a misdemeanor, it's charged because he was given a specific warning with respect to Sergeant DeLuca. He was then given a general warning with respect to Sergeant Walsh, and then he engaged in conduct that was witnessed by Captain Lavoie that led to his arrest. Once he's under arrest, he then, he's saying, I have a right, I have some sort of constitutional right to contest my arrest. There's no such thing. There's no such thing in the Constitution. That doesn't exist anywhere. If you feel like you have been unlawfully arrested, your forum for addressing that is court. You don't go in and say, well, now that I'm being arrested, it's time for me to get everyone to shut things down. Couldn't be any clearer. Would ask the court to make a finding with respect to both charges of guilt. Thank you very much.
Your Honor, the state website actually identifies DC as part of the legislative body. So
I'm not entertaining any further.
You're not entertaining anything. And I actually, there's one thing that I did forget. I was hoping I could get in there real quick.
I'm sorry, Mr. Staples.
No, because there's an exemption, part 3C of 642, disorderly conduct is disruption of any lawful assembly or meeting of persons without lawful authority. And the lawful authority comes from, like I said, Article 10, Article 30, 31, 32, and 22. Thank you.
Oh, yeah. What about the motion to dismiss?
Mr. Staples, so you're facing four charges, 2 charges for the first incident, 2 charges for the second.
Stacked, yeah, stacked.
With respect to the alternative theories on the first incident, I can see why you were removed from the auditorium. There was a warning from the governor. There was a warning from the sergeant. Then there was a warning from Officer Toluca directed to Walsh was a general warning. And then it's pretty clear that you said yeah after these warnings. And so, like I said, I can see why the state police removed you from the auditorium.
He said, I said, yeah, but I was telling you what I was charged.
Right. I mean, I get the sense that it seems the police perceived you to be something of a bellwether.
Yes.
And you could see that when you stood up, a lot of the other people stood up and turned their backs on the governor and council. So I think they rightly perceived that if you were getting carried away, then maybe other people might get carried away. So like I said, I can see why they removed you from the auditorium. And I can see why they believed that they had probable cause to arrest you at that point. And I think they did have probable cause to arrest you at that point. But the burden in this proceeding, in this criminal proceeding, is proof beyond a reasonable doubt. It's difficult for me to find proof beyond a reasonable doubt with respect to you saying yeah, and finding that that created a risk, as the statute requires, of disrupting the orderly conduct of business. I can see how they were trying to take preventative steps from you possibly doing that. But I think your statement of yeah, which was essentially the straw that broke the camel's back for them, was what precipitated them deciding that it was time to maintain order and remove you from the auditorium. Like I said, I think there was probable cause for your arrest, and I think the police were justified in removing you, but I can't find beyond a reasonable doubt that those actions constituted the criminal offense of disorder. Behind the curtain, I find that the state's proven its case beyond a reasonable doubt. I do find that you were acting purposely when you were screaming at the curtain and that you were yelling that you were being arrested and blank this, blank, and shut it down. And I think you were acting in a manner that was purposely disruptive, and in the language of the statute, you purposely caused a breach to the peace, public inconvenience, annoyance, or alarm by disrupting the orderly conduct of business in any public or governmental facility. So, because I found that the state's proven each and every element of that offense beyond a reasonable doubt.
Both charges?
Well, no, they're alternative theories, so I'm entering a finding of guilty on the purposeful. That is charge ID 1674436.
And is that a violation?
No, that's a class B misdemeanor.
Well, at that point, I wasn't asked to do anything. I was in a separate room. I wasn't even in the meeting anymore.
Yeah, but you've been asked to desist.
No, they didn't. They said I was under arrest behind the curtain.
Oh, I understand that you may disagree with the decision I made.
Of course I'm going to disagree with it, but it just doesn't, yeah, sure.
Does the state have a
I already
record?
predicted this anyways.
Your state would recommend $1,000 fine based on, like I said, $1,000 fine would have to be suspended for a year of good behavior and no attendance at government council meetings. And
Not gonna happen.
we would argue that this is substantiated. I know it's a high fine for the offense, but this is not Mr. Staples' first conviction for disorderly conduct, so I think it justifies that.
So, just so the court knows, I will not pay a fine if you give me one. You're gonna have to put me in jail for $150 a day, if that's what you wanna do. I can't afford anything, and even though there are people that will pay the fine for me, that's not gonna happen either. I will not allow somebody to pay a fine for me for something like this. And then what else was it? Suspended time, oh, the executives, I can't, so now I'm not allowed to participate in our government. They're trying to lock me out of participating in the government. So just like the bail conditions on the other case that say I'm not allowed to be within 1,000 feet or 100 feet of the executive council and all that, that as well is to keep me from having a voice and playing a role in the political process.
Mr. Staples, do you wish to be heard further on sentencing?
Yeah, I mean, I don't think any fine is justified in any way. You know, this whole process has already destroyed my life. I've had to take so much time out of my personal life to deal with this nonsense that I feel like that's enough. I'm homeless, okay? So whatever you want to do, you want to give me a fine, give me a fine.
Okay. Mr. Staples, on the court's finding you guilty, you're fined $1,000 plus the statutory penalty assessment of $240, $500 of the fine, and $120 of the statutory penalty assessment are suspended on the condition of your good behavior for a period of 1 year. Are you able to take care of the fine and penalty assessment this afternoon?
No, like I said, I'm not paying a fine, I'm appealing this as well. Just so you know, so I'm appealing this.
I'll know your appeal.
Yeah.
Anything further from the state? Anything further, Mr. Staples?
No.
All right, this hearing is concluded.
Prosecutors should be ashamed of yourselves.
Shame on all of you.
What was this?
We're gonna win on appeal. Don't worry about it.
And we have enough evidence of the state's wrongdoing to take to bring it up to the bar.
I guess not. I didn't hear anything about it. So I was going to leave here for that. I mean, as far as I'm concerned, that case is over. You know what I mean? Like, if I was supposed to be doing that other case at 12:45, then
It clarifies.
before they want to do it. I'll talk to you outside. I'll be right there.
And now you're going to use that against me. Shoot the eyes.
Right in the eyes. Mr. Freaky.
Shoot the eyes.
Liar. I mean, it's
If that isn't a definition of the peanut gallery. I don't know what is. Guys, I had to stay on. I'm getting yelled at. Never go to bed angry. God bless everybody. Kiss your loved ones. Good night. I will see you, hopefully, maybe, mañana. If not, Monday. God bless. Kitchen Court Cases is always on after me. Just remember, I'm Todd, and you have been served.